Welcome to Innovation School. I am Akshay Darade, and today we're diving into a crucial topic in our digital age, privacy law in India. In this comprehensive overview, we'll explore the evolution, current stage, and future of privacy legislation in the world's largest democracy. As we navigate through this complex landscape, you are all gain insight into how this law affect your daily digital life. The second point is the evolution of privacy law in India. Let's begin with a brief history of privacy law in India. Before 2017, privacy wasn't accessibility recognized as a constitutional right. However, on August 24, 2017, we witnessed a watershed movement. The Supreme Court of India, in a landmark judgment, officially recognized the right to privacy as a fundamental right under Article 21 of the Constitution. This decision set the stage for significant development in data protection. In 2018, another crucial judgment came in this Adar Act case. The Supreme Court upheld the constitutional validity of Adar but placed important restrictions on its use. Then in 2019, the Personal Data Protection Bill was introduced, marking India's move toward comprehensive data protection legislation. The key privacy law in regulation the India's privacy law landscape. So, India's privacy law landscape is shaped by several case pieces of legislation. Sorry. The Information Technology Act 2000 laid the foundation addressing cybercrime and electronic commerce. This was followed by the IT rules of 2011, which strengthened the data protection measures. The Adar Act of 2016 established the unique identification system. And finally, we have the proposed Personal Data Protection Bill, which aim to create a robust framework for data protection. Each of these laws play a crucial role in safeguarding our digital privacy. The IT Act and rules, the foundation of IT Act and rules. Let's take a closer look at foundation of India's digital policy. Privacy laws. The IT Act of 2000 was India's first step to forward addressing digital privacy concern. It primarily focused on recognizing electronic records and regulating cybercrimes. The IT rules of 2011 significantly strengthened this framework. They introduced key concepts like sensitive personal data and maintained that companies implement reasonable security practices. Importantly, these rules also established the requirement for obtaining consent before collecting or using personal information. This laid the groundwork for more comprehensive privacy protection in the digital realm. The Adar Act. The Adar Act balancing service delivery and privacy. The Adar Act of 2016 is a pivotal piece of legislation in India's privacy landscape. At its core, Aadhaar aimed to provide a unique identification number to all Indian residents, streamlining service delivery and reduce fraud. However, it has also raised a significant privacy concern. The 2018 Supreme Court judgment on Aadhaar was crucial. Will it upheld the Act's constitutional validity is also placed important restriction on its use, particularly by private entities. This judgment highlighted the ongoing challenges of balancing efficient government with individual privacy rights. The game changer, the Personal Data Protection Bill. Now let's discuss what many consider a game changer in India's privacy law. The Personal Data Protection Bill, first introduced in 2019, this bill aimed to create a comprehensive framework for data protection in India. It draws inspiration for the European Union General Data Protection Regulation (GDPR), widely considered the gold standard in privacy laws. However, it's important to note that the bill is tailored to India's unique need and digital landscape. Currently, the bill is under review and refinement. Its evolution and eventual implementation will significantly shape the future of data protection in India. So, understanding the PDP Bill K concepts. The Personal Data Protection Bill introduced several key concepts that are crucial to understand. First, we have the data fiduciary. This refers to entities that determine the purpose and means of processing personal data. Think of major tech companies or government agencies that collect your data. Next is the data principle. That's you and me, the individuals who data is being processed. The data processor is any entity processing data on behalf of the data fiduciary. The bill also implements consent and purpose limited, ensuring data is collected and used only for specified purpose. Lastly, data localization requires certain types of data to the stored within India's border, a concept aimed at ensuring data sovereignty. So, you are right under proposed laws. Under the proposed law, individual would have several important rights regarding their personal data. The right to confirmation and access allows you to know if a company has your data and what data they have. The right to collection and erasure enable you how to correct inaccurate data or how it deleted. Data portability lets you transfer your data from one several provider to another. Finally, the right to be a forgotten allows you have to limit dealing or delete your personal information from being publicly available. These rights are designed give citizen greater control over their personal information in the digital age. The overcoming heartless implementation challenges. Implementation comprehensive policy laws in India faced several significant challenges. At the base, we have the digital literacy gap. Many Indians are new to the digital world and may not fully understand privacy risk or their rights. Infrastructure limitation pose another hurdle, ensuring compliance across a vast and diverse country like India is the monumental task. As we move higher, we face the challenge of balancing innovation and protection. How do we foster technology growth while safeguarding individual policy? At the peak, we have complex issue of managing cross-border data flows in our increasingly globalized digital economy. The road ahead, future of privacy laws in India. Looking to the future, we can't expect continuous refinement of the personal data protection bill as it moved through the legislative process. We're likely to see an increased focus on emerging technology like artificial intelligence and Internet of Things as this pose new privacy challenges. Data localization and sovereignty will like remain hot topics with ongoing database about where and how data should be stored. Lastly, we can anticipate enhanced cooperation between government, industry, and civil society in shaping and implementing privacy law. This collaborative approach will be crucial in creating effective and balanced privacy regulation. So, India's privacy journey, a crucial junction. So the conclusion, India is at the crucial junction in its privacy journey, wherein significant progress from the recognition of privacy as a fundamental right to the development of comprehensive legislation. However, the real state lies ahead. The challenge is striking the right balance between the individual right and data protection on one side and national interest and innovation on the other. Another, how India navigates this balance will not only shape its digital future but could also serve as a model for other developing nations. Uh, Thank you so much, guys. As we wrap up, encourage you to stay informed about this development. They will shape not just how your data is handled, but also the future of India's digital economy. If you found this video helpful, please subscribe to the Innovation School channel for more insightful content or emerging trends and skills. So, thank you so much for watching, and remember, in the digital age, knowledge about your privacy right is power. Stay informed, stay empowered. So.